Hello, everyone. Welcome back to the Legalpreneurs Lab Geeky Guru in Residence series. And as you know, we have an amazing guru with us today in Peter Dombkins, who's going to chat with us about legal project management and its connection to transformation and innovation, and just draw on his amazing array of practical experience in this area. So welcome, Peter.
Thank you very much, Terry. Very kind introduction.
Absolutely enough from me, Peter, and over to you. Again, just absolutely delighted to have you here.
Terry, thank you very much, and a pleasure to be here. We're going to be covering how we can use legal project management to actually drive transformation within, whether it's your in-house legal team or your law firm. So not legal project management just for its own sake, but as an enabler, as a catalyst for change. And then as part of that, at the back end of that, we're going to look at how we can use LPM to help drive technology procurement decisions. And we'll close off with a look at some simple DIY legal tech tools that you can use to get started. All right, so we're going to start off with just a bit of an introduction to legal project management before we start getting into the nuts and bolts. So what is it? Less in terms of the mindset of our profession, or old mindset of our old profession. Who are we dealing with when we're normally dealing with trying to manage lawyers? Well, and yeah, so these statements. They're all, I guess, they're all truisms to a certain degree. They're stereotypes, but they do hold a degree of truth. And there's actually a degree of substantive research, mainly from the US. So if you don't like it, you can blame our US colleagues across the pond. But certainly, we do have a fixed mindset. Unsurprising for a profession with concepts like stare decisis. We always like doing things the way we did them before. Very rarely are clients happy to have the gung-ho lawyer that says, well, I know it worked 99% of the time this way, but let's try it the other 1% just to be new and innovative. No, clients are usually going to take a kind of a more risk-adverse approach. So we do sometimes have a fixed mindset. Unsurprising for a profession which really hasn't changed in many respects for over 300 years. We can make rapid assumptions and a bit of a ready, fire, aim approach, and we can buy into the client's urgency. So they're suddenly in a situation where they have a concern, a time-pressured concern, and suddenly we equally buy into those concerns. Instead of being the trusted, calm advisor, the steady hand on the rudder, guiding them through the storm, we can sometimes buy into their urgency. We can be a little bit pessimistic and skeptical. There's a research suggesting that pessimistic law students outperform optimistic law students at law school. We all passed law school, so what's that say about us? Poor communication. So we can, the leading cause of complaint against lawyers still year-on-year in Victoria, New South Wales, ties with negligence is poor communication. And why trust other people? We can tend to be low trust and somewhat siloed in our mentality. So that's kind of the old profession, the old mindset. Now it is starting to change, and we're seeing not only in university courses, such as what I teach through the University of New South Wales, but through institutions like the Centre for Legal Innovation, like this one here, and these types of CPT and CLE initiatives. We are starting to absolutely shift the dial for the profession, but nonetheless, these are some stereotypes of what we're dealing with to date. And what impact does that have, that mindset? Well, some inefficient behaviours. We can spend lots of time doing things in a repetitive way, in a manual way that potentially could be done in a better way, such as searching for information. Research suggests that we, as knowledge workers, and that's what we are, we can spend up to 30% of our time searching for information. Now, how much time do you spend searching for that one email, or that one document? I'm sure we did a piece of advice on this somewhere, and you spend a lot of time, an inordinate amount of time looking for it. Yeah, and it's trying to co-locate that holy trinity of tasks, emails, and documents in the one location. Oftentimes, this unfortunately split across multiple systems, between say Outlook or Gmail, and then a document repository, and then a separate tasks repository. And of course, if we can't find what we're after, then it may well be easier to recreate it. which is its own form of absolute inefficiency, because then we're recreating stuff which we already had, and if we could only find it. So that's pretty inefficient behavior. We can also tend to make choices based on gut feel rather than actually data-driven decisions. Now that's a process because oftentimes we don't have the underlying systems and data to then actually make those informed decisions. Now we're going to get in later into this session on we're going to look at cognitive biases and how that impacts pricing decisions, and how you can actually use legal project management and the structures around legal project management to help create the data set in the first place, which will then let you make more structured, data-informed decisions. And leading off from that, we also then have difficulty, and this is particularly true for in-house teams, but it can equally be true for private practice. We have difficulty quantifying the value that we actually deliver outside of, because we don't actually have strong metrics in this area. Now we've at PwC, where I'm director, we've recently released a report specifically looking at the types of decisions, metrics, and underpinning data that law, in particular this case in-house legal teams, will use and find useful. So there's a hyperlink in this deck, which I believe will be shared, and if not, I will certainly make that link to that report available. But I strongly encourage you, it's a free thing, I strongly encourage you to have a peruse through it in your own time. Now, it wouldn't be a legal project management training session if I didn't mention the T-shaped lawyer somewhere. No doubt this concept's now well saturated in the market, so I'm not going to spend much time on it. But for anyone that hasn't seen it, it was first developed by McKinsey back in the 1980s, then popularized for the legal sector by Smathers. I actually was delivering a session a couple of months ago, and I had Smathers dialed in to the session when I talked about legal project management. It was delightful. So Smathers, if you're here, shout out. But the concept's pretty simple. We have a deep vertical legal knowledge, but then the idea is that we want to have along the cross of the TV or the horizontal part an array of other competencies that we don't necessarily need to be subject matter experts in, but we do need to be aware of as because no longer is it just law as an academic discipline. It's no longer law as just black letter law. It's law as a service. Yeah, there's only a very few group of people that only get to do the law and nothing else, and they're called judges. Everyone else has to usually deliver law as a service and have to understand things like project management. You can kind of tilt your head to the right and read through these: continuous improvement, change management, product development, things like leadership and strategy, risk management, and technology. Again, don't need to be an expert in all of them, but you do need probably to be aware of how they impact your day-to-day, and ideally be able to have a sensible conversation with an expert in one of these areas to know how they can help you. So today, hopefully, we'll have a bit better understanding of what the LPM, legal project management part of that is, which leads us to what is LPM? So key rule number one. So every legal matter that you work on is a project by definition. It has a start point, it has an end point, and it has a deliverable. That is the most simple definition of a project that I can come up with, and I didn't actually come up with that. It's based off, you've got a more formal definition there, developed by the Project Management Institute, one of the world's largest professional bodies of project managers, I'm a member, and they developed something called the Project Management Body of Knowledge, or PMBOK, which is like the Bible for project management, if you will, developed way back in the 70s, I believe, and it's kind of gone through a lot of iterations since then. So if every legal matter is a project, then it stands to reason that the people working on those legal matters, so lawyers, they're project managers and project team members. Of course, there's a problem here. When we all went through law school, we were subject to the priestly 11. All the fan favorites: constitutional law, admin, real property, IP, and the like. There was no project management 101 in there. There was no business development. We might have got some of this on the side and maybe through some electives, but not core curriculum. So that's why courses like this exist. But when we say project management, you're probably thinking, like I've got this little image on screen here. You're probably thinking maybe not quite so well dressed on a work site, but you're thinking hard hat, high vis. You're thinking engineering, right? Maybe defense procurement. You're thinking infrastructure and buildings, that kind of civil engineering. You're thinking that kind of project management, and that's fine. So what happens when we apply project management to professional services like legal? What is legal project management? And you can see up on screen there as a foreshadowing. What we do is we adapt traditional project management for legal services. Now, why do we do that? Well, because of this. This is, in all its glory, the project management body of knowledge. This is PMBOK. Isn't it a thing of, it's a thing of beauty. It brings a tear to my eye. I love it. Of course, I've got it in deliberate small type because I don't want you to read it to start off with. There are 49 separate groups of processes and plans in there, and there's hundreds of individual subplans and activities grouped broadly according to, you can see on screen, initiating, planning, executing, which is their form of delivery, monitoring and controlling, which is basically reporting, and then closeout, which everyone talks about, no one does. But you have these, and there's a lot of processes in here. And this is best practice for how you would build a building. My dad was a builder. I grew up in building sites, so I can kind of talk with some authenticity to this. This is exactly what a major contractor would use. And how do they do it in practice? Well, for each one of these plans and processes, there's an associated resource. So there's a risk management plan, and there's a risk officer. There's a quality assurance plan and a quality office. There's an overarching program plan and a program director. There's a very complicated schedule and a team of schedulers who do nothing other than update a Gantt chart. Not a job that I'd want, but some people love it. Yeah, there you go. So they have associated resources for all of these plans. And effectively, you go to the major contractors and there's like project managers managing other tiers of managers, managing other tiers of managers. So Ponzi scheme of project managers, right? They're all there and that's great. Works really well. But you probably figured out one problem here. It's very resource intensive. And that's where the problem is, because when it comes to in-house legal teams and private practice, we don't have those kind of resources. It's the lawyer is not only delivering the legal work, they're planning, reporting upon, and even developing best practice for the legal work all at the same time. So if I were to go to a lawyer, and I know you're no doubt all busy, often true that legal teams in-house are some of the busiest people in that organization, and we all know about the concerns about the profession as a whole as being the burnout profession. We all work hard, so we're all working hard, and we're going to then suddenly I'm going to layer in as a project manager and say, hey, on top of the long hours you're already working, can you just have an extra, say, 10 or 20% of your time devoted to developing up all these extra documents, all these extra plans, risk plans and quality assurance plans and communication plans, just to make me as a project manager happy, just for compliance sake. Well, you're probably going to tell me no. You're probably, in fact, going to have a few colourful words as well, but you're going to certainly not necessarily do that. Why? Because you don't see the value in it. And you don't have the resource. It's not like you have a whole team of project managers to do all these plans for you. You're busy doing the legal work. So that's what we do in legal project management. We take elements of this, the best parts, the most relevant parts to lawyers, and we adapt them. We don't just put a big L in front of this for legal and go, there you go, swallow this. No, we take the best bits, we adapt them, shrink them down, and we make it fit for purpose for the legal sector. So let's kind of switch gears a bit here. For those who haven't seen this particular image, it's been around for a long time. It's an oldie but a goodie. So it just shows you many different perspectives. But the reason I've got it up here is for the definition of a project stakeholder. Project stakeholder, by definition, is anyone who is positively or negatively impacted by a project. I'm just going to repeat that for to make sure it sinks in. Anyone positively or negatively impacted. So that's quite a broad remit of people that have gotten, they're being, that are relevant to your project. It's a little bit like the internet. Everyone's going to have an opinion. So, what do you do as the hapless legal project manager? As what do you do as the senior or the partner or the person leading or working on a legal matter? How do you make everyone happy if they've all got a subjective opinion about, what does good look like? Well, that's where we start coming up to our first core project management tool. It's the Triple Constraint. Now, you may have come across this before, the time, cost, quality triangle. Maybe you haven't, but in fact, you probably have, because here's a different version, more popular, popular speak, the good, fast, cheap. Now, you might have heard of this, and the idea is choose any two, or if you're having a really bad day, choose any one. But if you want to kind of contextualize it, an easy way to imagine how this works is just think about your Amazon delivery process. If you want it high quality and you want it, so you want it all signed and signatured and delivered, um, delivered securely, and you want it tomorrow. Well, you're paying for the privilege, aren't you? But if you don't want to pay for the privilege, well, it's probably going to take a little bit longer. And if you want it quick and you don't want to pay much for it, well, you're probably going to have to go with a budget carrier. It may not be the best quality and may not even arrive. And of course, in the middle is La La Land, which is where clients and us as consumers all live. We want the best, we want it tomorrow, and we don't want to pay anything for it. So that's basically your time, cost, quality triangle. It applies to every legal matter that you'll work on. Every legal project, or every project rather, is affected by these constraints. And there'll always be a push and a pull between them. And that's the reason we've got this here. This tool is, or as a construct, if you will, it's a really good enabler for discussing with clients the constraints and impacts of decisions. So if they come and say, hey, I need this thing by tomorrow, you're like, okay, sure, we can do that. But it'll probably have an impact on cost. Or I may not be able to deliver all of the scope because it's just not feasible, but we can get you a slimmed down version of what you need by tomorrow. Or maybe the time isn't the problem. Maybe, or their biggest constraint, maybe it's cost. Maybe it's like, look, I want an outcome, but I cannot exceed this particular cost. Maybe because it's pre-approved, it's a budget item on a client side. Maybe that's just all they've got. In which case, okay, then we're scoping to that. And we're not going to be, so if it's depending upon if it's a low number or a big number, we know that we're going to have to, we can or can't do things in order to meet that particular threshold cost. So you can see this is going to be a very useful tool, and we found it useful. Oftentimes in-house teams are already intuitively using this tool as a conversation with their business units, but hadn't formalized it. So this now just starts to put a label to what you may already have been doing, and equally so for private practice, having a discussion with their clients. Starts to put labels and enables you to have a slightly more constructive conversation about what the impacts of what good looks like for the client and what the trade-offs might have to be in order to deliver a solution which is good in their eyes, not just yours. And just on what we're talking about, flip side of what does good look like, let's talk about that big dirty F word of failure, which no one talks about. There's an interesting piece of research done by, again, the Project Management Institute only a couple of years ago. This is a global piece of research looking at the underlying causes or the leading causes of project failure across all industries, so not just legal. And it's in tiny text there, but you can kind of see it. I'll put the big takeaway on screen. You read it for yourself. It's unbelievably delivering the wrong thing, which I find incredible, absolutely incredible. Because where do we spend all our effort? Doing the work. But do we spend the extra fraction of % of effort to work out at the start whether we are in fact delivering the right thing? No, far too busy doing the work. Or what about halfway through? Should we check that we're still delivering the right thing? Maybe the situation has changed. Oh, no, far too busy doing the work. Even though planning is, as shown by the data, is the single biggest risk mitigant that you can take to deliver a project which is successful. I'll just read out the small type here. Leading cause of project failure: changes in organizational requirements, changes in project objectives, and inaccurate requirements gathering. So not actually working out what the end users want or the client wanted properly in the first place. So this is really where we've got to start. And I've got the little link there to one of the fan favorite Simon Sinek's, which is start with why. Starting out with understanding what we're doing and what success looks like is core before we get anywhere near getting into the deliverables, which is what I talked about earlier in terms of not panicking and not instead of that ready, fire, aim and jumping in straight away with the solution into solution mode, stopping, pausing and breathing, and then delivering a considered opinion. This might have been I can actually just as a bit of a self shout out with one of the previous sessions that I delivered for Centre for Legal Innovation about a month or so back, a couple of months back, was on project management in times of crisis. So if you want to go a bit of a deep dive into how to deal with that kind of immediate pressure and how to pause and create some space for yourself to plan, I recommend you have a look at the CLR website and have a look at that previous session. You may find some useful information there. So let's put it all into practice, because now for the rest of this session, we're going to get into some more of the details about the core aspects of project management. But before we do that, let's have a look at the kickoff meeting. So this builds off what we've just talked about for the past 15 or so minutes. We need to first of all understand the big picture. What are we trying to achieve? What does good actually look like? Then secondly, is this actually a priority? And this is a big one in particular for in-house legal teams. So some of the factors that you may consider when you're considering is this a priority are risk, urgency, the amount of effort involved, and degree of strategic alignment with your corporate objectives. Because this helps you separate between the urgent and the important, so to speak. And then, have we done this before? Again, harking back to that earlier conversation about the amount of time that we spend searching for previous knowledge and or simply just rebuilding previous artifacts and knowledge and advices because we can't find it. So have we actually done it before? Big time saver if we have, and building off our previous experience and lessons learned. But we really should be doing all this big picture stuff. Doesn't have to take long, but we should be doing this big picture stuff before we start getting into the details of detailed work breakdown structures and work streams, identifying the key stakeholders and internal and external, the budgeting, and then key aspects around communication in terms of how we track changes, how we're going to communicate progress and track deliverables both internally and externally, and how importantly are we going to identify and changes and potential disagreements and resolve disputes. So that kind of that governance structure. But this session, we're really going to have a look at some of the delivery strategy. Right, this is it. Work breakdown structures. This is the fancy term for a checklist. This is best practice for how you should be tracking and just tracking your tasks and identifying what your tasks are in the first place. It's really simple. Doesn't require any tech. You can draw this up. I'd like to think you did it digitally, but heck, you can even draw it up on a piece of pad and paper. But, this could be in Word. This could be in Excel. There are plenty of other project management tools that also can help you out. And we'll have a look at some of them later on, or at least list them out. But what is in a work breakdown structure? Well, 4 columns of information. First of all, there's a what we're doing, so it works. Then who's doing it, so responsible, when it's due, and its status. Has it been done? Those simple 4 columns, and the status is usually around not started, in progress, paused, or completed. But they could be equally particular phases of your project, say, in litigation. But you need these 4 elements to really be able to project manage something properly. Because if you don't know what you're doing, you don't know who's doing it, you don't know when it's due, or you don't even know if it's been done or not, you can see it becomes progressively difficult to actually manage it. So we highly recommend at the start of the project, you draw one of these up and you start trying to fill it in. Now, it's okay if you can't fill in all the boxes straight away. We recognize that in certain projects, there may be a degree of uncertainty. You can't see all the way into the future. Litigation being the easy example. Day one, it's going to be pretty hard to plan out all the way through to appeal exactly what's going to happen, considering that you've got the other side actively working against you to try and disrupt your theory of the case, and you're pending upon various court decisions or third-party decisions. So you may not be able to fill it out all that. But in certain other transactional contexts, you might be able to do it all that from the start. You may have that degree of certainty right from the outset. But fill it in as best you can. And it will start to identify gaps. We're actually not quite clear on who's doing it. We've actually got a few dates that we don't actually have any certainty on, or we're actually not really quite sure what is required in this particular work stream. That's a call to arms for you to then actually, as your project team, to actually work out what those details are. And this is a foundational component of project management and legal project management. There are very few thou shalts in legal project management. Most of this, what we're going to say is should be adapted to the circumstances. But in this case, this is, I would say, bordering on mandatory. You need to understand core aspect of scope of what you're doing before you can build anywhere. There's a reason why in the project management body of knowledge, when they list out all the areas of competency, guess what the very first one is? Scope. It always starts with scope and what you're doing. So from something like a work breakdown structure, we can actually then use that for estimating, project estimating. And in fact, there's a couple of ways we can go about estimating, and the core way is what we call a bottom-up approach, where we start off, here's our friend, a work breakdown structure. We start off with understanding what the work streams and key sub-activities are. We work out who's doing it, and then we work out how long they're going to be doing it for, and then we multiply that out by the relevant rate. And that might be either a duration or, say, a quantity, and we come up with a total cost. That's why we have it as a ground-up estimate. And guess what? This is just as relevant for in-house legal teams as it is for private practice. Don't think that private practice are the only ones that have to develop up an estimate. Highly recommend that the in-house teams should also be doing this at the outset before they brief externally, so they have themselves some rough idea of what the ballpark numbers should be, or at the very least be putting it to their external counsel in the form of the work streams, the key phases that they would like to have an estimate broken down by, rather than just getting a simple lump sum figure. Get your external counsel to provide a broken down estimate by phase. Much easier to then compare apples with like apples when you're comparing different vendors. Just while I'm at it, the other version of estimating is actually called top-down estimating, where one of the derivations we can borrow from the school of Agile, where they have t-shirt sizing. Simple concept. You go to you have a sense, is this a small, a medium, or a large matter? And then you go to a colleague and ask them, likewise, what do you think? Is this small, medium, or large? And so, if you think it's a large thing, or rightfully, if you think it's a small thing and they think it's a large thing, clearly someone has missed something, right? So it's just a matter of not just having your own eyes look at it, getting an extra pair of eyes to sense check how big or small you think this is. Now, there's a slightly more sophisticated version of the same thing called reference class forecasting. I've got a reference down there to a chap by the name of Flivberg, who did a deep dive on this. This concept actually won a Nobel Prize for economics way back, I think, in 2002. So it's got a degree of structure around it. But the concept, basically building off what I've just said for top-down estimating, that you find a like group of similar matters, your reference class, and then you just simply take the average cost. So you take out the human bias. And we'll get to human biases in just a sec. Last thing I want to while we're on the topic of estimating, this is another useful tool in project management, which has been around in project management for some time, developed by the US Navy decades ago. Not really taught outside of project management and engineering, though, unfortunately. So here we are, bringing it to lawyers. It's called the Program Evaluation Review Technique, or PERT. What it does is we ask you to work out what's the worst outcome. Okay, now let's work out what the best outcome is. And then somewhere in the middle, what do we think the most likely outcome is? And what we do is just a bit of simple math. It's the worst outcome plus 4 times the most likely outcome plus the best outcome. And we divide the whole thing by 6. It's a weighted average towards the middle. For those that are into standard deviations, it's your first sigma, basically. That it is a weighted average towards the middle, and it's a very powerful tool for helping us work out what the average, most likely outcome, or most likely, this applies equally to cost as it does to time, but what the most likely outcome is, but it still takes into account what might be a worst outcome or an extreme best outcome. So it's not just strictly in the middle. So that's a little tool for you. But of course, hard to do all this stuff without some degree of work breakdown structure or some degree of structure of understanding what we're doing in the first place. While I mentioned, we're on the topic of cognitive biases, and this is why it's useful to have project management to provide a degree of structure to avoid them. This here is a codex of human cognitive biases. I've got a link down there on Wikipedia where you can see all this, and you can it's all hyperlinked, so you can go into it. It's a bit of fun. Really realize that we unfortunately are a flawed species when it comes to making estimations and probabilistic estimations. A couple of the relevant, particularly for, say, pricing, we've got optimism, bias, where we underestimate probability of undesirable outcomes, and planning fallacy, which is pretty similar, where we underestimate costs and completion times and risks. Those two things are pretty fatal in the context of estimating pricing, as you can imagine. And there's a couple of other interesting ones about like misinformation effect, where information that we've received more recently can colour or overshadow information that we received historically. Negativity bias, where we tend to remember things that didn't go so well more so than we remember the good times. So we'll remember that chance, that thing where it was a really big cost blowout or really big time blowout, and we'll remember less where things actually came in under budget and under time. Normalcy bias, where we don't take into account extreme events. We only take into account things that are kind of within our lived experience. So we'll take into account the 1 in 10 year event, but not the 1 in 200 year event. And just to show that we're a hot mess, I've talked about optimism bias. Why not pessimism bias? So it depends upon, in terms of us, a bit of a hot mess in terms of which biases are applicable any day of the week, depending upon what we had for breakfast and how we're feeling. So to overcome all of that, highly recommend using a slightly more structured approach to, which is underpinned by things like the humble work breakdown structure. So instead of relying on gut feel, we rely upon structured data and the structured approach. Just while we're talking about work breakdown structures, one of the other useful things we can do with a work breakdown structure is then we can use that as the basis for developing up, say, a Gantt chart, which is a really powerful communication tool. This is the example of a Gantt chart that I've just developed up in PowerPoint, just for a generic procurement. That's very easy to see what the key work streams are, some of the sub work streams, and roughly how long they occur in relation and when they occur in relation to each other. So these are really powerful communication tools and really help us understand visually what the key work streams are. A slightly more detailed version of the same, by the way, I should have mentioned here, chance to show off my amazing PowerPoint skills. No, I'm really going to do it again just because I can. This is how you work. This is how you read a Gantt chart, by the way. Top left to bottom right, which is oftentimes why traditional project management is referred to as the waterfall technique, because the tasks cascade nicely down the page. Two of the benefits of doing this, because it is a knowledge tool. If you develop up one of these, easy enough to just do on a plan on a page. But they are, as I said, communication tools, not just for training new lawyers that may be joining your team that haven't, I remember when I was a junior lawyer, baby lawyer, working in the project and infrastructure finance space. I would only ever get to see, certain elements of the documents and the overall process. Why? Because it was all sitting here in the partner's head, which is wonderful for them, but less so for me, trying to understand how I fit in the world and what I was doing, how that benefited the team. But equally so, this is true for clients. They come to us because we're subject matter experts as lawyers. We understand what's going on. And this is true for in-house and private practice. But oftentimes they don't. Legal for them is a bit of a black box. In an in-house environment, they just send it to legal and they don't oftentimes appreciate the actual time required or the actual inputs and outputs required. You'll have a business unit, a project lead for a business unit has developed up their own schedule, their own project plan, their own Gantt chart, and they've allocated a line item to legal, which might be a month or so. That's when a legal will get all their stuff done, having no real appreciation that actually legal needed to be involved a lot earlier, and to make some help make some decisions. And in fact, some approvals that they're requiring or expecting might take months to get. So it's important for legal to have their own Gantt charts, if only to be able to communicate the value of what they do and actually what they do to their clients. Slightly more forensic version of a Gantt chart can be done in Excel. There's plenty of other tools that do this, but Excel's an easy one. Here's our handy friend, the work breakdown structure of the tasks, status, resource, and this time I've got the start date and the end date, and all I've done is add a calendar to it. So it's a calendar which runs linearly across the page, the start date, and we just simply fill in the bars according to when each task occurs. So you get a nice visual representation of what in project management land we refer to as dependencies. Now, when one task does one task have to end before another task starts? Do they have to both start at the same time? Do they have to both end at the same time? It's a nice visual way to depict that. So once we've done all this breakdown of what we're doing, how does that actually help us in terms of a broader optimization approach? Well, there's an interesting, we can start to take a few notes from the methodology of process optimization and lean, which is a methodology first developed replicating Toyota back in the 1980s. Very much taken from the manufacturing sector. But what it recognizes is that a legal matter will be made up of lots of different parts, lots of different work streams, and not all of them are the same. It's not a homogeneous whole. We can some of them, we might, if we're trying to optimize them or trying to improve them, trying to improve their efficiency, whatever that might mean, we might have to treat different parts of the legal matter in different ways. So if we have parts of the legal matter which say take a long time, but in terms of overall value delivery to the client, maybe are less valuable, we've still got to do them, but maybe in terms of the end deliverable, they're not as valuable. And a good example here might be, for example, due diligence, where what does the client really want? They want the exceptions report, don't they? They want to know the delta. They want to see the red flags. What do I need to be worried about? Now, it'll come down to the risk appetite of the client in terms of whether they, in order to get that exceptions report, that due diligence report, whether they wanted a whole bunch of junior lawyers and overseen by senior lawyers individually page turning every document, on site in the country, or maybe they're happy for an AI engine to trawl through that tranche of documents and flag issues, which are then reviewed by a senior lawyer. Or maybe they're happy for an alternative legal service provider based in a lower cost jurisdiction to do that initial review, and then send it to a non-jurisdiction, in-jurisdiction lawyer, senior lawyer, to then review their output, or any combination of the above, where the ALSP is also using AI. It comes down to the risk profile, as I said, of the client. But ultimately, what they're really after is the exceptions report. So if we have tasks which are taking a long time, but we think that in terms of the ultimate value, they're more a means to an end. Well, hopefully there's a chance, and I've already flagged it with suggesting AI. We can template this stuff, we can automate this stuff. Why? Because we've got to do it. So let's reduce the pain. Let's reduce how long it takes. You might have aspects of your legal matter which are already don't take very long, and again, not much value. There may be certain internal approvals, certain scheduling of meetings, certain sort of administrative stuff which we have to do. But again, not much. That doesn't take time and not much value. The key question here is, does it need to be done by you at all? This is where labour arbitrage models and outsourcing models really come into play. So, or internal shared service delivery centres, which a lot of the top tier firms have developed. But equally so, the ALSP, Alternative Legal Service Provider market, is growing. I think it represents about 6% of the market globally at the moment, and it's certainly growing. So, lawyers are high cost, expensive, and well-trained resources. Do we need them doing a whole bunch of highly structured admin, which with appropriate supervision and safeguards might be able to be done elsewhere? Then we have tasks which don't take very long, but they are very high value. The task up here is one touch has to be the right touch. Good example, thinking about litigation context, might be trial. Now, it takes a couple of weeks, but in the context of an overall litigation, which has taken a couple of years to get to that point, that's a couple of weeks of white-knuckle terror in front of a judge or a magistrate. So it doesn't actually take, equivalent in transactional setting might be financial close, again, or execution, which is why we have completion checklists. When you've got everyone in the room to sign the right documents, you want to make sure the documents are right and ready for execution, and we're not doing the process again. So this is where quality assurance becomes quite important. We're drawing right the first time. We want to avoid rework at all costs for these types of works, for these activities. And finally, we have things that take a while and have high value. The way I've sometimes described this is why we went to law school. These are things which require in-depth legal thinking. Certainly, private practice loves this type of activity. I could put a big dollar sign over it, right? Because we're not going to get much pushback from our clients. Why? Because the work is high value. They like it, and it takes a while. So we're going to be able to put a decent dollar value on it. So we as lawyers what do we want to be doing? Well, clearly we want to be doing more of the stuff which is high value to clients, right? But there's only so many hours in the day. How do we do that? When we've still got to do all of this, all the things that are on the page. We've still got to do, or it's got to get done somehow. Well, that's why for these tasks we ask, maybe we can do it less, maybe we can do it faster, or maybe we can do it cheaper. Of course, the only way we get to this point is to have already a clear understanding of what it is we actually do. To have an understanding of what the key average, the normal types of work streams or work streams and phases are for the particular standard types of matters that we do. On average, how long they take and the types of resources required. This is starting to sound a lot like legal project management. So legal project management and that core activity of templatizing and structuring your work is a core enabler to start to be able to understand how and what you should be optimizing and recognizing, as per this diagram, that there are different approaches. So there's certain tasks which actually may, like particularly if they're high strategic value, actually, no, we don't want to outsource that. No, we don't. Yeah, but there may be other tasks which absolutely we don't want to outsource. This is and just to really bring it home, this is a little bit of PwC knowledge to give a sense of some of the actual questions we will be asking. We're doing a diagnostic and going into a client, say an in-house team, and try and understand what they do. These are precisely some of the questions that we will be understanding. What work can they do less? How are we eliminating low-value work? This I mentioned earlier, the low-touch delivery. Maybe there's options here for self-service, so that queries don't even need to get to the legal department in an in-house context in the first place, because they're standardized to the point where we can actually have, for example, a bot supplemented with a bit of document automation to, for example, for standard queries or NDAs. Doesn't even need to touch the legal team then. And supplemented with appropriate processes to make sure that we're not getting unnecessary requests coming into the legal team in the first place. In terms of doing it better, how can we start to automate the work that we do, standardize and simplify the work that we're doing, and making sure that doing it in the right place. That's very much the outsourcing model. So this is real practical stuff. This is not theoretical. This is core of how a strategic consultancy organizations such as our team will go in and actually ask to try and dissect and diagnose what a legal team is doing. Just to put a bit of color to this, this is research done by Altman Wheel. They had their chief legal officers survey just from last year, which started to identify what innovation initiatives are in-house teams actually using. And don't worry, next slide's for private practice as well, for those lawyers, for those that are working in law firms. What I liked about this slide, so the way you read it is the bars, they're the percentage of respondents who are actually using the tactics, and I've highlighted them here. So these are the top scoring ones for internal efficiency initiatives, cost control initiatives, and external cost control initiatives. These are the ones that basically everyone are doing. And you can see there, everyone's looking at tech tools, everyone's looking at how to improve internal procedures, and everyone's trying to require outside counsel to have budgets. Great. So this, and on the budget one, this is very ties back to what I just said about trying to, not only just get a single line item number, but actually get them to break it down by phase, structured phase. That's great. I highly recommend you do all of this, but this, frankly, is just keeping up with the Joneses. This is just what everyone's doing. What I'm most interested in is those areas where not many people are doing them, and you look at this is where the line comes in. The line represents those who are using the tactic found that they experienced a significant improvement. Right, so the boxes I've highlighted are where not many people are doing them, pardon me, but those that did them experienced a significant benefit. And first cab off the rank, and I'm unapologetic because I'm biased here, but project management. Less than 20% were using it properly, and of those that used it, nearly 60% said there was a significant benefit. So data doesn't lie here. What I found it fascinating, this on the middle row. So we've already said everyone's trying to require outside counsel to have budgets, but only a quarter of in-house teams are actually training lawyers to actually manage those budgets, which I found incredible. Something you might want to look at. And in terms of, we mentioned the outsourcing earlier, you can see in the bottom right there, less than 10% are actually outsourcing to ALSPs, but of them, over nearly 95% said that it had a significant benefit. So something really to consider. In the context of private practice, so law firms, and we're just looking at their usual approach to innovation strategies. Great. So everyone's creating a culture of collaboration, whatever that means. But let's see what less people are doing. Actually getting in place specialists in pricing, process, technology to actually support and drive change. Only about 30% are doing it, but of them, over half identified significant benefits. This is a real clarion call to arms to consider getting a legal operations specialist to help with your transformation journey. So with that all said, let's have a look at how legal project management might help us with, say, some legal tech procurement decisions. We're going to start off with looking at the Gartner tech hype cycle. This is specifically looking at the one for legal and compliance in 2019, so very pertinent and relevant. I'm assuming most of you may have come across the Gartner hype cycle series before. Those that haven't, you can see we've got a couple of different categories of where different technologies are in their stages of maturity and relevance to the market. So let's start at the good end. Start with what good looks like, put our project management principles into practice, and what they call the plateau of productivity. These are platforms which are really embedded and become part of BAU in how we deliver legal work. And you can see there, we've got content collaboration platforms and continuous data protection. And in particular, we've got, say, Microsoft Exchange and SharePoint with about a 45% market share, really dominating the market here. And in fact, those who are using SharePoint know that these tools now have data protection and security pretty much baked in with audit controls. But there are a suite of other tools out there. They're in the content collaboration space, whether it's, say, HiQ, whether it's the OneNote. We've got the Atlassian series product, of course, with Confluence. So quite a few areas in this. And this is, as I said, now becoming part of BAU. Clients are expecting these types of tools. We have the slope of enlightenment. So these tools are, and these you can see like e-discovery, nearly over an $11 billion market in 2019. So they're by no means emergent tech. This stuff's still pretty. The business case has been proven, and we are now growing it out. Areas like contract lifecycle management, enterprise legal project management, and matter management. Tools, for example, like LawView, definitely in there. But we start getting what I'm most interested in and relevant for this discussion about project management helping with tech procurement decisions is things that are in the peak of inflated expectations. I think the kind of the title self-describes there, and the trough of disillusionment. Sad place to be. So peak of inflated expectations. Basically, if you're going to any sort of legal tech conference, online or otherwise, you are going to get inundated with all of these buzzwords. Everyone's going to have something to say on using either bots, using deep learning, using intelligent applications, smart contracts. It's buzzword bingo here, right? And all of these toys look very shiny. Question is whether all these tech have got a business case to prove. Okay, they're interesting and they may work in other sectors. For example, robotics process automation, which we'll get to in a moment, is very useful in tax. I should know this. PwC has one or two people that specialize in tax. Audit company, so audit firm. But the question is for peak of inflated expectations tools, do they have a business case which is relevant for legal? And that's where we get into the trough of disillusionment. They're no longer shiny. They've been around for a bit, and now's the time to get real. Will these tools actually and genuinely make a difference for lawyers day to day? And you can see things in there like blockchain and robotic process automation software, which is basically helps transform data from one configuration to another. Very useful in tax, where they're dealing with spreadsheets and financial spreadsheets all the time. But is it relevant for lawyers who mainly deal with words? Yet to be seen. And so that's why those tools sit there. Now, we were talking about the most common in-house tools and tech platforms. Yes, matter management is definitely going to be up there. E-signatures and doc management, all quite relevant. Interesting when we get down to areas like process and workflow management, which only about 30%. This is based on Clock's 2019 survey. Only about 30% of people are using process and workflow automation tools. So definitely, if we want to try and get ahead of the curve, areas to look at. If we're looking at for private practice, and this piece of research done by Macquarie Bank very recently, we can see again that things like time recording software, document management, very clearly taking the lead there, and automate. Good to see that document automation, only half of them were using it, but definitely a growth area. But then you can also see on the bottom, you see areas like, and this is why these tools were in the trough of disillusionment, areas like blockchain and bots. These areas are chatbots we've got at the top of there. Not many people using them. Why? Because the business case is yet to be proven. So when we're talking about legal tech, we've really got to be thinking about it as a strategic enabler. This shouldn't be tech for tech's sake. As I've said, oftentimes in transformation, legal transformation should be tech-enabled, not tech-led. There's a very wide range of there's a very broad ecosystem of legal tech solutions. You can see a couple listed on screen here. But really what we've got to start with is use more of a design thinking based approach, or what's oftentimes referred to as a human based approach to problem solving, to understand the why. In fact, our core principle and tenet of design thinking is fall in love with the problem. So we start truly understanding what the problem is before we jump into solution mode. And you can start to see some of the parallels with what I was mentioning in legal project management, and countering that initial mindset of lawyers to jump in with the ready, fire, aim approach and make an initial decision. That doesn't just apply to when they're talking about legal matters. It applies equally to when lawyers are thinking about what tech's going to be relevant. They oftentimes spot, and it can be the bright, shiny thing, the stuff which is in the peak of inflated expectations, the thing they've heard about at the conference or saw in the latest news grab. And they see that and go, oh, wow, that's a great point solution. I need that. Let's place it in, without really understanding the root cause of the problem they're trying to solve, and recognizing or not understanding that sometimes it may not even be a tech issue. It might be a process issue or a human issue which could actually solve what they need, the deeper need. There's a tool that we often use in design thinking and lean called the 5 whys, where you basically get to act like a little kid, 5-year-old for a couple of minutes, and just ask why. All right, so you start off with the problem, and then, well, why is that? And then someone come up with the answer, and then you ask, okay, why is that? And you come up with an answer, and you go, why is that? And hopefully by that third or fourth time, you end up starting to get to the root cause of what the problem is. So we highly recommend you do that approach, and starting off understanding what the problem is, and as per project management, understanding even what you're talking about in terms of the content, the structure of your matters, before you launch into trying to buy a particular point solution for technology. And one of the other reasons we'll do that, and I'm just about to finish and we'll get into some Q&A for a couple of minutes, is oftentimes these platforms have overlapping areas of functionality. We keep a bit of a database on a couple of hundred of the top legal tech platforms out there, the mature ones. There are thousands of emergent legal tech platforms. We keep a database of some of the most mature ones across a range of different functionality. You can, as reading across the headers along the columns on the top of the screen here. And I've just sub-selected for those, say, expert systems. M indicates where this is a key advertised feature of the platform, and X indicates where they've otherwise got capability. And you can see for expert systems, including things like Checkbox AI and Joseph and Nyota Logic, that these tools actually do more than just expert systems. A great example I like using is DocuSign. Everyone thinks of it as just the e-signature platform. Actually, it does a lot more. It recently acquired Spring's CM. It even does smart contracts and chain bots in terms of. Very few people know that though. So oftentimes we hear in-house teams thinking, oh, I've got a problem. I've got this tech stack, but I've got this problem. It doesn't really solve it. Oftentimes that tech solution actually does solve the problem, but they're just on the wrong version, or they haven't, they've only got a limited license, and if they bought this extra module, it could actually solve for them. ultimately what we're trying to do here is help legal teams make more informed procurement decisions instead of having to buy a number of discrete point solutions, which then all require integration and separate licensing and separate costs and separate training. Isn't it better if we rationalize your tech stack and only choose one or two solutions which actually cover the field of everything you want, which is less licensing, less administration, and less training costs, and much simpler for the end users because they've only got to navigate one or two systems. But of course, to do that, we need to understand what your actual requirements are. And to do that, we need to understand the course your course structure of the types of work that you're doing. In the dying minutes, I'll just quickly, if you just want to add a kind of a freebie here, just a suggestion of low-cost tools to get you started. I've got a link at the top to a very recent discussion on no-code or low-code tools by Stanford Law School. And that's in the realms of task management, just to get you started. But if you want in task management, highly recommend looking at any of the products I've got listed on screen. In terms of project management, these are OneNote, Teams, and Planner in the Microsoft suite. We've got Atlassian's Trello. Other separate tools are Monday, Asana, and if you also just look up task management within the Google Marketplace, you'll identify a range. All of these tools are pretty low cost and a great way to get started to help you start structuring your legal work. If you're interested in looking at workflow automation, we've got DocAssemble, which is a free site. Does require a bit of training, self-training, but it's free. We've also got the Microsoft 365 Flow and Power Apps series, and again, Google workflow in the Google Marketplace, and you'll come up. And I've got some links to, there's plenty of training, free online training, plus the Udemy series of training, which is also excellent. And they're usually pretty cheap. We're talking like $20 for a course. And last but not least, a couple of different background resources to help you better understand impacts upon the overall legal sector. And in the bullet points there, I've got some, in terms of legal tech, some great additional resources you might want to consider. The Law Hackers Weekly, great little email which identifies leading emergent legal tech. We've got the Legal Tech Buyer's Guide. There's the Society for Computers in the Law, the UK version, also the Australian version. I happen to be the vice president of that one currently, so a bit of a plug for that. And we've actually got a journal, so if anyone's super interested in this and wants to submit journal articles, please get in touch. And of course, we've got the Australian Legal Technology Association, ALTA, which is again a bastion of knowledge for all things legal tech. With that, Terry, that has been, and to the minute, may I add, as an excellent example of form following function is legal project management and how it can be used to drive strategic transformation within your legal team.
Thanks, Peter. That's brilliant. And of course, in the interests of biased plugs, don't forget to visit the Centre for Legal Innovation website as well, which has just a huge amount of videos, podcasts, research, etc., available to you too. Peter, I'm going to put one of the questions that we've got here to you real quick, knowing that we're kind of on the time. The question was, what proportion or I guess percentage of the overall project costs, in your experience, are clients willing to pay for project management?
Brilliant question. Now, I'll start with saying that first case, NASA have actually got some research in terms of how much time you should spend on project management, and then I'll get to how much it should cost. NASA, when they build things, they build one of one. Right? They don't build a whole bunch, they build one rocket, and they really want to make sure it doesn't blow up, right? So they really take a lot of time and countenance into project management. And they did a min-max on it, and they realized that the best, otherwise you can start chasing minimizing returns, right? So the min-max on it was about 10%. A project time and cost should be spent on project management in order to deliver the best outcome. I'm a big advocate of that you get what you pay for. Unfortunately, we still live in a market where there is the horrible term of value adds. I suggest that project management should be done, well, it depends who's doing it. I've trained thousands actually of lawyers in project management. I'd like to think that the senior lawyer or the partner working on a matter was actually competent in project management themselves. Great. And if they can do that within their legal work, I think that's absolutely fine. But if it's sufficiently complex that you do need a subject matter expert to come in and supplement, and I'm talking, large scale, complex litigation, royal commissions, significant, multi-billion-dollar transactions, multiple work streams, where it really would benefit from having also supplemented by a subject matter expert, particularly at the start, to help set up the reporting framework, the governance structure, and then I think that absolutely should be paid for. It doesn't need to be a lot. It doesn't mean, because once you've got the subject matter expert to help up front, then it goes from project management to more project administration. The rules of the road have been set up. The cadences have been set up. We know that what types of meetings and who's reporting to who, right? We then move into project administration, which can absolutely be done then by a mid-ranking or even a junior lawyer to help things ticking over. Whether they need to charge for that particular cost, that can be a discussion. But I think absolutely, if you're having an SME come in and support, that should be costed. That doesn't need to be expensive. But to give you a kind of a reference point, when in my previous employer, I was usually charged out at a senior lawyer rate, because that's normally what you'd be expecting the senior lawyer to be doing as well. So I'd be charged out at a similar rate to that, and it would be potentially a couple of days, if not a week's work right at the start of the transaction to help things get moving, and then I would step back. So that's not a hard number, but it just gives a kind of an estimate, approximate estimate for the kind of, and that's for that's where you'd have a couple of $100,000 in legal fees, or $1 million in legal fees. Obviously, for smaller matters, then that all scales down.
Peter, it's always a pleasure to have you here. We so value our association with you. We are so delighted to be able to call you a geeky guru of the lab. And today, as we always do, thank you so much.
Terry, that's absolute pleasure. Delighted to be given the opportunity to share the knowledge and share the love. So thank you. And yes, it's an honor to be calling myself. I'm certainly geeky, and nice to be called a guru. So happy to have that title.
Viva project management, right?
That's right. I think that's definitely going to be a new call sign on my email. So thank you.
Bye, everyone.